Afternoon friends. The Honorable President of the GST Appellate Tribunal to be formed administered his oath on 6th of May 2024 and on 24th of April 2025 the GST Appellate Tribunal procedural rules have been notified. It is expected that all the 31 benches of the GST Appellate Tribunal would now be soon be operational, and therefore it is very important that industry should be ready with their appeals and applications to be filed before the appellate tribunal, because once it is notified that this is the date when the president of the GST Appellate Tribunal has entered office, within 3 months of such date the pending appeals have to be filed before the GSTAT. Even in case you have a favorable order from the appellate stage in your favor, then the department within 180 days of such date when the president enters office can go for an appeal against such order, and in case the department does, then you have the option which you must use as a taxpayer to file a memorandum of cross objection within 45 days. The maximum time which the GST Appellate Tribunal can condone the delay, and that also after filing the condonation application, is for the main application 3 months, that is 3 months plus 3 months, and for memorandum of cross objections is 45 days, that is 45 days plus 45 days. Beyond this, the GST Appellate Tribunal may not be even able to condone the delay. Therefore, it is very important that industry is ready with their applications and their appeals for filing before the Appellate Tribunal, and mind that all the appeals filing have to be done online. The GSTAT portal is already active to certain extent, and therefore taxpayers may scroll through that to understand the way of filing of the appeals and other matters. It is said in the CGST Act that within 1 year of filing of the appeal, the GST Appellate Tribunal should dispose of the applications. However, such time limit is not very strict, and therefore considering the pendency, huge pendency of the cases across, when the Appellate Tribunal becomes operational, the matters may get delayed, and therefore again it is in the taxpayers' interest to file their appeals fast as soon as the appellate tribunal is formed, and also to mention their matters so that in case they require they can be heard earlier. As you all know that pre-deposit of 10% was already paid by you at the first stage, and an additional 10% of the taxes needs to be paid in case your matter is pending. As per circular 224, you would have already paid an additional 10% pre-deposit. But mind that from the day when the Finance Act 2025, which was enacted on 29th March 25, is notified, then even in case your order has only a penalty element, even that 10% pre-deposit needs to be filed on the penalty amount in case your order only consists of a penalty. The appeal before the GSTAT needs to be filed in form APL 05. So, in addition to the appeal, the application in APL 05 should also be kept ready by the taxpayers. In case you could not produce, or you were barred by sufficient cause from producing certain evidences, then such additional evidences you can produce before the GST Appellate Tribunal by taking leave of the court in case you have sufficient reason. For example, in case your supplier has given you a declaration for paying the GST for a demand of ITC at your end after the first stage has disposed of its application, then you might produce this as an additional evidence before the GSTAT by taking leave of the court. Mind that in case any of your dispute in your order in appeal considers place of supply, is related to place of supply, then you cannot file your appeal before the state bench. You have to file your appeal before the national bench, that is the principal bench at Delhi. In case you are filing memorandum of cross objections, then you need to use form APL 06 and not APL 01. So forms are very important while filing of the appeal before the GSTAT. A very important power of the GSTAT, in addition to confirming, annulling or modifying a demand, is the remand back of an order in appeal to the first stage or an order in original to the adjudication stage, right. So this power of the GSTAT, which is not available at the first stage, this would help many of the taxpayers in case there is a matter of fact which has not been appropriately dealt with at the adjudication stage or at the appellate stage. Then the power of remand back can be exercised by the GST Appellate Tribunal. However, mind that friends, in case you lose before the GST Appellate Tribunal, then only in case it is a question of law, a matter of law, and not in case of matter of facts, you can go before the High Court within 180 days. And in case the High Court does not dispose of your application or does not grant you a stay within 180 days, then you may have to pay off the entire demand even when the matter is pending before the Honorable High Court. Therefore, as I said, the GST Appellate Tribunal is a very important and possibly the last appellate stage before the High Court, which you should take advantage of as a taxpayer for genuine cases. Interlocutory applications like condonation of delays needs to be filed separately, as we have already seen in the GSTAT and we see in the ITAT also. And mind that in addition to a fees of maximum 25,000 for normal applications before the ITAT, before the GSTAT, there is an additional 5,000 rupees fees which needs to be filed for interlocutory applications also. And in case an affidavit is required, such affidavit needs to be filed. Timelines are very strict for filing of appeals as well as interlocutory applications, and therefore it is very important that the timelines are strictly followed. For filing of vakalatnama by the advocate or the employees of the taxpayer or the chartered accountants, company secretary, cost accountants, you need to file it with GSTAT form number 4. You should not just file a vakalatnama, which generally we file before the ITAT and the GSTAT. You have to accompany it with form number 4. In case your matter is pending before the High Court, and this is very important. In case your matter is pending before the High Court, it is very critical that you should try and get it disposed of at the High Court, because as we have seen in precedents before this, it may be that when the GST Appellate Tribunal is formed, the High Courts may transfer all the cases of GST to the GSTAT. So, for all those High Court matters of GST, try and mention your matters and get it disposed of at the earliest to the best extent possible. Last, for every order in appeal, one appeal needs to be filed before the GSTAT. This is very important. We'll understand with an example. Say in case you have 3 show cause notices for a particular matter, 1 against the taxpayer and 2 against the directors. And even at the first stage, the first stage officer passes 3 orders in appeal, then you need to file 3 applications before the GSTAT also. However, in case you have 3 SCNs, 3 orders in original and 1 order in appeal, the first stage officer has bundled all the 3 orders in original and passed 1 single order in appeal, then you need to file only 1 application before the GSTAT. So, this is a very important point which one needs to note while filing of appeals before the GSTAT. So, friends, we hope this video helps you to take cognizance of the operationalization of the GSTAT and to prepare your applications as soon as possible, to file it as soon as possible before the GSTAT as and when it is operationalized. Thank you very much for hearing. Do like, subscribe and share this video. Stay tuned. Thank you very much.